Respected and distinguished colleagues in legal profession, learned members of the bar, friends from civil society, my brothers and sisters, good morning to you all. Today, I wish to speak on an issue that goes to the very heart of our constitutional democracy. FCRA Amendments, Anti-Conversion Laws, and the Indian Constitution, whether religious freedom is under attack. The issue is not merely about the Foreign Contribution Regulation Act, my friends. It is not merely about anti-conversion laws. It is about something much deeper. It is about whether every Indian citizen, irrespective of religion, can enjoy the fundamental freedoms guaranteed by the Constitution of India without fear, discrimination, or governmental overreach. My friends, Baba Sahib Dr. B.R. Ambedkar, the father of Indian Constitution, reminded us that the Constitution belongs to equally to every citizen. The state has no religion. The state has no religion, and the state shall not prefer any religion over the other religions. The Constitution has only one commitment: to liberty, equality, fraternity, and justice. Article 14 guarantees equality before law. Article 21 protects life, dignity, privacy, and personal liberty. Article 25 guarantees freedom of conscience and the right freely to profess, practice, and propagate religion. Article 26 protects the right of every religious denomination to manage its own religious affairs and institutions. These are not concessions granted by any government. They are constitutional guarantees enforceable against every government. Whenever these freedoms appears to be curtailed, it becomes our constitutional duty to examine whether such restrictions satisfy the test of fairness, equality, and opportunity. Then FCRA, regulation, whether it is a regulation or a control. No responsible citizen disputes that foreign funding should be transparent. No democracy can permit money laundering or foreign political interference. Therefore, reasonable regulation is legitimate, but the regulation must never become domination. The proposed amendments to FCRA have generated serious constitutional concerns because they empower the government to assume control over the assets and foreign funded resources of organizations whose registration expire or cancelled. If registration is not restored, that governmental control may become permanent. This fundamentally change the nature of the regulation. The constitutional question therefore becomes, is the government regulating the financial accountability or acquiring permanent control over the independent civil society institutions, non-governmental organizations, and minority religious institutions? That question deserves careful constitutional scrutiny. My friends, the contribution of Christian institutions, if we see for generations, these institutions have served India quietly and selflessly. They established schools where none existed. They built hospitals in remote villages. They educated the marginalized sections of the society, Dalits and tribal children. They cared for leprosy patients. They provided disaster relief. They served people without asking which religion they belonged to. Millions of beneficiaries are Hindus, Muslims, Christians, Sikhs, Buddhists, and people of every faith. When institutions performing such public service face increasing regulatory restrictions, citizens naturally ask whether accountability alone is the objective or whether institutional independence is itself under pressure. My friends, official data placed before the Parliament shows that the thousands of NGOs have lost FCRA registration during the recent years. After 2020 amendments, thousands of non-governmental organizations have either lost their registrations or have been subjected to increasingly stringent compliance requirements. Between 2016, 2017, and 2021 and 22, more than 6,600 NGOs lost their FCRA licenses, according to the information placed by the government before Parliament. Independent organizations have reported even larger numbers. Amnesty International has estimated that by March 2026, over 21,900 NGOs lost their FCRA registrations. Whatever the precise figure may be ultimately, my friends, one conclusion is difficult to dispute. India's civil society space has become significantly narrower than before. A vibrant democracy requires not only strong governments, it also requires a strong and independent civil society institutions capable of serving citizens without unnecessary interference. Then, recently, United States Congressman, the Republican Party Congressman Riley Moore, publicly expressed concern regarding the proposed amendments to FCRA. He argued that the proposed law could permit governmental control over churches and religious charities. He further suggested that such developments could affect India-United States relations. Whether one agrees with his political assessment or not is beside the point. The important point is this, my friends. The world watches India because India is the world's largest constitutional democracy. Our greatest answer to international criticism has never been angry rhetoric. Our greatest answer has always been faithful adherence to our constitution. Then, my friends, parallel to these developments, FCRA amendments, several BJP-ruled states have enacted anti-conversion laws. The latest 13th state is being Maharashtra. Preventing forced or fraudulent conversion is unquestionably a legitimate governmental objective. Nobody supports conversion obtained by coercion. Nobody supports fraud. Nobody supports intimidation. But constitutional democracies must ensure that laws aimed at preventing abuse do not themselves become instruments of abuse. Many of these laws contain expressions such as allurement, undue influence, misrepresentation. These expressions are often broad and capable of multiple interpretations. When criminal liability depends upon vague terminology, constitutional concerns naturally arise. Then, my friends, freedom of conscience. Religion is perhaps the most personal decision a human being can take. No government can enter the human conscience. No police officer can investigate faith. No bureaucracy can regulate belief. The Constitution protects not only the freedom to retain one's religion, it also protects the freedom to change one's religion voluntarily. If an adult citizen freely chooses another faith, that decision belongs to that individual and not to the state. This is the essence of liberty, my friends. The problem of criminalization. Many anti-conversion laws make offences cognizable and non-bailable. Some require prior notice before even conversion. Some permit complaints by relatives or third parties. Some effectively shift the burden of proof onto the accused. These provisions deserve careful constitutional examination. A law intended to prevent coercion should not itself create fear among citizens exercising their constitutional rights. My friends, the impact of these laws is felt most deeply among socially and economically weaker communities and marginalized sections. The Dalit Christians, Adivasi Christians, people dependent upon educational institutions, hospitals and charitable organizations. If charitable institutions become financially weakened, while religious choices become increasingly criminalized, the combined effect can significantly burden the everyday life of vulnerable sections of communities. This is why these issues cannot be examined in isolation. My friends, what is the judiciary's constitutional duty? Numerous constitutional challenges are pending before our constitutional courts against anti-conversion laws. The judiciary has historically protected fundamental rights whenever they have come under the threat. The Supreme Court has repeatedly reminded us that the constitutional rights are not ornamental promises. They are living guarantees. Timely constitutional adjudication therefore becomes essential. Justice delayed in matters concerning fundamental rights may itself weaken constitutional freedom. Equality before law. Article 14 demands equal treatment. Regulatory laws must operate uniformly. They should not create even an appearance of selective enforcement. In a constitutional democracy, my friends, public confidence depends not only upon the fairness but also upon the visible appearance of fairness. Citizens must believe that every organization, irrespective of ideology or religious affiliation, is governed by same legal standards. That is the true meaning of the rule of law. My friends, Baba Sahib Dr. B.R. Ambedkar warned that the constitutional morality cannot survive merely because a constitution exists. It survives only when constitutional institutions, including higher judiciary, faithfully uphold the constitutional values. Liberty without equality becomes privilege. Equality without liberty becomes oppression. Fraternity alone binds both together. Those words remain profoundly relevant today. My friends, the issue before us is not Christianity versus Hinduism. It is not majority versus minority. It is not government versus opposition. The real issue is this: will India continue to remain a constitutional republic where every citizen enjoys equal freedom of conscience? Can charitable institutions serve society without unnecessary governmental control? Can an adult freely choose his or her faith? Can constitutional rights remain meaningful irrespective of who occupies political power? These are the questions history will ask us. Governments will change, political parties will change, will come and go, but the constitution must endure. Let us therefore, my friends, reaffirm our collective commitment to the ideals enshrined in the preamble: justice, liberty, equality, fraternity, and secularism. Let us defend not merely the rights of one community, but the constitutional rights of every community. For when the liberty of one citizen is weakened, the liberty of every citizen becomes less secure. As Dr. Ambedkar reminded us, the Constitution is only as strong as the people who are prepared to defend it. Let us resolve to defend the Constitution with courage, with reason, and with unwavering constitutional faith. Jai Bhim, Jai Bharat, Jai Constitution.